everyone, my name is Chang Lee. Inventions are the result of human intellectual labor and creativity, and they contribute significantly to life, production, and business. However, commercialization of patented inventions faces numerous obstacles as patent infringement becomes an increasingly prevalent occurrence in Vietnam. The simplest way to determine patent infringement is to file a patent infringement assessment with the Vietnam Intellectual Property Research Institute, or VIPRI for short. However, this assessment will cost a considerable amount of money, so it is critical to comprehend the fundamental principles and laws for evaluating patent infringement in Vietnam before submitting a request for patent infringement assessment with the VIPRI. We are pleased to introduce Mr. Nguyen Vũ, partner and IP attorney of Ken Fox IP and Law Office, who will assist us in better understanding how to determine patent infringement in Vietnam. Mr. Nguyen, what are the bases to determine and evaluate the likelihood of patent infringement in Vietnam?
In order to assess the likelihood of patent infringement in Vietnam, it's required to compare the patented invention with the product intended for commercialization in order to determine the identity or equivalence between the two. This comparison is based on the scope of patent protection, which is determined by the patent's claims. Therefore, in order to determine the likelihood of patent infringement in Vietnam, it's required to thoroughly examine the patent's claim in order to ascertain the scope of protection afforded to the patented invention. Please note that the structure of a patent claim typically includes one or more claims in the form of an independent claim and a dependent claim. You can review the claims in the invention title Sewing Machine with Easy Template Replacement to better comprehend the independent claims and dependent claim. As you can see, claim 1 in this claim is the independent claim, and claim 2, 3, 4, 5, and 6 are the dependent claims. An independent claim shall include all of the basic technical features that form a necessary and sufficient collective to identify claim subject matters to achieve the intended purposes, to distinguish claim subject matter with the known ones. A dependent claim is a claim that refers back to another claim or claims before it, containing all of the features of the claims from which it depends and adding further features to develop the claim subject matter into a specific variant. Dependent claims that share one or more additional features may be appropriately grouped into one dependent claim, which refer to one or more independent and dependent claims from which it depends.
What principle or rules should be used if a product is suspected of potentially infringing patent rights in order to determine whether that product is identical or equivalent to the patented inventions?
In order to determine the identity or equivalence between the suspected products and the patented invention, is required to rely on Article 11 of Circular 11 issued by the Ministry of Science and Technology in 2015. Specifically, two technical features are regarded identical if they have the same nature, utility, and method of utilization, and share the same connection with the other features stated in the claim. Two technical features are regarded similar if they have similar or interchangeable natures and basically the same utility and method of utilization. Therefore, it's possible to conclude that the suspected product is deemed identical to the patented invention if all their substantial features are identical or equivalent or interchangeable. The suspected product is deemed equivalent to the patented invention if most of the substantial features are identical or equivalent. Please note that two sides shall be considered equivalent if they have similar natures, the same objective, and basically similar ways to achieve the objective.
So, if the suspected product does not contain one or some of the basic technical size or feature mentioned in the claim of the inventions, is there a patent infringement?
These questions often asked by the patent owners and stakeholders. Article 11 of Circular 11 issued by the Ministry of Science and Technology in 2015 stipulates that if a product or part or process in question does not contain at least one basic technical feature stated in the claim of the patent claim, then there is no it can be regarded as neither identical nor similar to any product or the part or process protected under that claim. Therefore, it is conceivable that if the product does not contain at least one basic technical feature in any patent claim, there is no patent infringement.
Can you give an overview of patent infringement determinations so that rights holders or related parties can easily understand?
Yes, the approach of determining the likelihood of patent infringement can be generalized based on the following formula, where A, B, C, D, and E are the basic technical features. A is the protected invention and B is the suspected product. Figure 1, B does not infringing A. The protected invention A includes 4 basic technical features, that is A, B, C, and D. The suspected infringing product B has only 3 features, that is A, B, and C. In this case, product B is not an infringing element of the rights to the protected invention A. Reason: product B does not contain all 4 basic technical features of the invention A. Figure 2, B infringing A, literal infringement. The protected invention A includes 4 basic technical features, that is A, B, C, and D. The suspected infringing product B includes 5 characteristics, that is A, B, C, D, and E. In this case, product B is an infringing element of the rights to the protected invention A. Reason: despite the addition of the E side, since product B already contains 4 basic technical features of invention A, product B is an infringing element of the rights to the protected invention A. Figure 3, B infringed A, equivalent infringement. The protected invention A includes 4 basic technical characteristics, that is A, B, C, and D. And the suspected infringing product B consists of 5 characteristics, A, B, C apostrophe, D apostrophe, and E. In this case, product B is an infringing element of the right to the protected invention A. Reason: despite the addition of the side E, since size C apostrophe and D apostrophe are similar to the size C and D of the protected invention, product B is an infringing element of the rights to the protected invention A.
Thank you very much for the practical and useful sharing. Determining the likelihood of patent infringement is a complex process, but it is governed by clear principles. Patent owners or related parties can independently analyze the risk of patent infringement by comparing the intended manufactured products to the patented inventions. This will be the initial basis for determining the next step, whether to continue or cease manufacturing or how to reduce the risk of damages in the event of a patent dispute. Please select a professional IP service provider to work with if you want your business to grow in the proper direction. Thank you very much for watching our video. Goodbye and see you again.